A court fight over gun permit delays just turned into something far bigger than most people realize. Pause. And if you think the government can stall your rights forever with paperwork, interviews, and endless waiting, what just happened should get your full attention. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a serious mistake with your carry rights. Hit that button now. Here's the big picture. A lot of people are seeing wild headlines, saying a court just ended permit delays everywhere, or that all carry permits are about to collapse. That is not exactly true. But here's what is true, and it matters a lot. Courts, the Department of Justice, and a growing group of states are all treating extreme gun permit delays like a real constitutional problem. Not an inconvenience, not bad customer service. A constitutional problem. And that is a major shift. So let me break this down for you in plain English. First, you need to understand the legal foundation. Back in the Bruen decision, the Supreme Court said states can use objective permit systems in some cases, but the court also gave a warning that too many people ignored. The court basically said a shall-issue system can still become unconstitutional if officials use long wait times or huge fees to block normal people from carrying. That matters because it means the government cannot play a dirty game where it says, sure, you have the right, and then makes you wait a year and a half to use it. And that brings us to what just happened next. In Los Angeles County, gun owners challenged the sheriff over huge delays in concealed carry permit processing. We are not talking about a few extra weeks. We are talking about delays that plaintiffs said could stretch to many months, even up to 2 years. A federal judge allowed key parts of that lawsuit to keep moving forward. That is important because the court did not shrug and say, too bad, the government is busy. Instead, the court said the people challenging those delays had a real case worth hearing. Now, this is where it gets interesting. That private lawsuit was only the start. The DOJ stepped in and opened an investigation into the Los Angeles County Sheriff's Department over those same kinds of delays. Then the DOJ went even further and filed what it called its first affirmative lawsuit in support of gun owners. According to the department, it reviewed more than 8,000 permit applications and found shocking numbers. The DOJ said only 2 approvals came out of that pile, and some interviews were being scheduled as far as 2 years after a completed application came in. Think about what that means in real life. Imagine you live in a high-crime area, you follow the rules, you fill out the forms, you pay the fees, you show up when asked, you do everything right. And then the government basically tells you, come back in 2 years. That is not a right you can use. That is a right sitting in a file cabinet. But here's the crazy part. This is not just a California story. You also have a growing fight over non-resident carry permits and travel. One of the clearest examples came out of Massachusetts. A New Hampshire man was charged there for carrying without a Massachusetts license, even though he was a lawful gun owner from a state where no permit was needed to carry. The challenge argued that Massachusetts put non-residents through a costly and slow process that they could not reasonably navigate just to travel armed. And a coalition led by New Hampshire, joined by 24 other states, backed that challenge. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let me explain why the Massachusetts fight got so much attention. The states backing that challenge said the system looked like pay to delay. Their point was simple. A constitutional right should not depend on whether you can pay a fee, wait months, and beg an official to decide you are suitable. Reports tied to that case said non-residents could face a $100 fee, delays ranging from around 40 days to as much as 170 days, and a vague standard that let officials decide whether someone might maybe possibly be a future risk. That kind of loose rule scares a lot of gun owners because it leaves too much room for personal opinions. Here's the part nobody's talking about enough. Even though the Supreme Court later declined to hear that Massachusetts case, the support behind it still tells you where this fight is going. 25 states do not jump into a Supreme Court case by accident. They did it because they see permit delays, high fees, and vague standards as the next battleground after Bruen. So when you hear DOJ and states back it, here is the honest version. They are not all lined up in one single case with one giant national order that wipes out every permit delay in America overnight. That would be a huge overstatement. But they are lining up behind the same basic idea in different places. The idea is that the government cannot pretend to honor your rights, while dragging the process out so long that your rights mean nothing. That is a very big deal. And there is more. The DOJ also sued the Virgin Islands Police Department, saying the territory created an unconstitutional permitting process through unreasonable delays and extra conditions. The department said applicants faced slow decisions, weird added requirements, and even rules that looked too much like the old proper cause system the Supreme Court already struck down in Bruen. So now you have a pattern. Los Angeles, the Virgin Islands, pressure over out-of-state permits in places like Pennsylvania, and support from multiple states in the Massachusetts travel case. Piece by piece, the message is getting louder. Rights delayed can become rights denied. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's why this matters to you, even if your county is not in a lawsuit right now. Most people think the big danger is a flat-out permit denial, but the truth is, delay can be just as damaging. If your permit office sits on your application for 9 months, 12 months, or longer, you may never get a formal no. Instead, you get something much harder to fight. Silence, endless status checks, excuses about staffing, a request for one more form, one more interview, one more background review, one more delay. And that is exactly why these cases matter. They target the trick itself. Here's a hypothetical example to explain this. Let's say your state says permits must be processed in 90 or 120 days. You apply on January 4th. The office tells you your file is not complete until they decide it is complete. Then they keep you in limbo until August. On paper, they may try to claim they followed the law. In real life, you are blocked for 8 months. That kind of game is what more courts and more lawyers are starting to look at. Second, this matters if you travel. Have you ever wondered why you can drive across a state line with a valid driver's license, but your carry rights can turn into a legal trap the second you cross a border? That is exactly what makes these non-resident cases so important. In places with strict local systems, you may be legal at home and suddenly facing criminal charges somewhere else. That means you cannot assume your permit or your home state carry rights protect you everywhere. Third, this matters because a lot of viewers get one thing badly wrong. They think Bruen automatically fixed all this. It did not. Bruen gave gun owners strong language, but local agencies still control the day-to-day process, and some of them seem willing to test how much delay they can get away with. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners who get these updates first. Click subscribe. So what should you actually do with this information? First, know your state deadline. If your law says 90 days or 120 days, write that down. Save it, screenshot it, print it if you have to. Second, document everything. Save emails, save receipts, save application dates, save every notice and every rescheduled appointment. If you ever need to challenge a delay, memory is weak. Records are strong. Third, do not assume a delayed permit is the same as an approved permit. I know that sounds obvious, but when people get frustrated, they start making dangerous choices. They say, well, I applied months ago, so I'm probably good. No, do not make that mistake. Until your permit is actually approved, you may still be exposed to criminal charges depending on your state. Fourth, if you're traveling, double-check the destination state, the route, storage rules, magazine limits, sensitive place laws, and whether non-resident permits are even available. Most people think I'm legal at home is enough. It is not. Fifth, if your permit office is blowing past the deadline, talk to a lawyer in your state who knows gun law. Not your buddy at the range, not a guy in a comment section. A real attorney who handles this area. And let me say one more thing that shocked me when I dug into all of this. Some of these fights are not really about a single form or a single office. They are about whether government can turn process into punishment. Because if the state can bury a right in delays, fees, interviews, and vague suitability calls, then the right still exists on paper, but not in your life. That is why this story is bigger than one county and bigger than one state. It is about the next front in the Second Amendment fight. Not always bans, not always confiscation. Sometimes just delay. Quiet, boring, technical delay. And that may be more dangerous because people miss it until it hits them personally. This information could literally expire as new rulings and settlements come down. Subscribe now because the next video explains exactly what you need to do if your permit office blows past the legal deadline. So here's the takeaway. No, there has not been one magic nationwide ruling that instantly wipes out every permit delay in America. But yes, the legal ground is moving. Courts are taking these claims seriously. The DOJ has started suing over extreme delays. And a coalition of states has backed the argument that long waits, high fees, and vague standards can gut your rights. If that trend keeps growing, the days of hiding behind endless permit backlogs may get a lot harder for states and local agencies. Pause. And if you want clear updates without the hype, subscribe right now and stay with me on this channel. I spend the time digging through this stuff so you can protect yourself and your family. Final simple disclaimer, this video is for education only. Gun laws change fast, and every state is different. Before you act on any of this, check your local law and speak with a qualified attorney.